agenda, House Bill number 25. We'll look at that on Tuesday, but I wanted to put that out there for everyone on the committee to look at. Ask that you come to me if you have any questions or problems. It's pretty simple. It's a one-sentence bill. So let's move to House Bill number 493. We have a strike all because we have added some language. This just is a pretty simple bill, requires that or allows counties to maintain electronic format of law books in their courtrooms and in public law libraries. The additional language that we put in is a recommendation from the Code Committee. Currently our statute has some requirements that requires CD versions of the code to be made available. We needed to just update that and provide kind of reassess the number of sets of codes that can be requested by different agencies. Pretty much a housekeeping bill. Are there any questions? You all in favor? Aye. Opposed? All right. The next, the remainder of the bills on this agenda are all from the Children's Justice Commission, and I don't think Judge Hudson is here, but they were all requested and of course have been through the House. The first one I'm going to call up is Bill number 1127, which deals with durable legal custody and guardianship. This would allow youth courts to consider durable legal custody and durable legal guardianship as a dispositional alternative in child welfare cases without having to exclude adoption. So in other words, if there cannot be reunification, the statute did say there had to be no reunification or adoption. This just excludes adoption and says no reunification. Present law requires exclusions of both, as I just said, and this would allow an alternative that they think would be more workable. There may be a situation where a reunification is not available due to the safety deficiencies of the parents, but family members are available and willing to take the child. And his notes tell me that this is in keeping with national recommendations. Have any questions on House Bill 1127? I have a motion, title sufficient, do pass. All in favor? Aye. Opposed? Next, House Bill 1129, termination of parental rights, clarify jurisdiction of county and youth courts. This is just a restatement of the current, what is in our statute now, to make it a little bit easier to read. I think it was confusing the way it has been in there. It is nothing new. It just clarifies that if there is a proceeding in county court, if the county court is sitting as the youth court and already has jurisdiction, then they can entertain the termination of parental rights. Can I hear a motion? Motion is title sufficient, do pass. All in favor? Aye. Opposed? 1131, call up 1131. It looks at the definition of endangered throughout this section. Endangered is used. It takes out the word endangered throughout this portion of the statute and substitutes danger of a significant risk of harm. So it takes out in danger and says in danger of a significant risk of harm, makes that change throughout the statute. We're in accordance with model legislation, kind of current, updating our code a little bit to have a more specific standard. Are there any questions? Do I have a motion? Derek? Senator Simmons, I'm sorry.
Thank you, Madam Chair.
Yes.
My question is, you say it's consistent with model legislation. I was just trying to find out the rationale of where the language came from.
Again, this is the recommendation from the Children's Justice Commission, from Judge Hudson, who is the chair of that. They think it's more specific language rather than just using that one term, in danger, in danger of a significant risk of harm, that kind of is a little bit more explanatory.
I mean, do we know if it's from other states or?
From his notes that he provided me, I would believe it's from other states. He doesn't have a listing of other states, but it is from model legislation.
Thanks.
Title sufficient do pass. All in favor? Aye. Opposed? Next, I'm going to call up House Bill 1134, and we do have a strike all on that to just clean up a little language that we found. So 1134 concerns when there's an out-of-state adoptive parent. And so it clarifies the statute and provides a requirement that the interstate compact on the placement of children home study should be done before the adoption when there is an out-of-state parent. It also would allow a single parent to adopt a child if that parent is married, but they're living separately, living apart from the spouse for whatever reason. So if that were to happen, if there were a couple who's living apart, one couple wants, for whatever reason, one parent wants to adopt, they can do that, and that child would solely be the child of that parent. The consenting adoptive parent would be the only legal parent of that child. That is an explanation of the bill. Do I have any questions? Yes, Senator DeVar.
Thank you, Madam Chairman. And it's not on the language. I think the language on the amendment is good. One thing I've had an issue with in Champion Court dealing with adoptions in the last few years, and it deals with the language on regarding home studies on line 111.
Yeah.
It requires a home study to be completed by a licensed adoption agency, experienced social worker. As you know, when there's an adoption and TPR and adoption, there's a guardian ad litem appointed. And the GAL technically represents a child and makes a recommendation whether a TPR and adoption should proceed. And in case, all the cases I'm aware of, the GAL goes out and does home studies. But that is not allowed to be sufficient to meet the home study requirement by the chancellors, at least in my district anyways. And so I'm not going to make an amendment now, but I'd like to, something we can think about and talk about is to allow GALs to be appropriate people to supply a home study to the court, because the parties have to pay for a GAL, then they have to turn around and pay for a home study to be completed, you know, which is at least $1,000, and so in some cases they can't afford that, and so that holds up a lot of adoptions. So if it's something that we could talk about at some point and get with Judge Hudson to see if we can amend that to make GALs appropriate party to complete a home study, I would appreciate that.
I think that would be appropriate, and we can maybe take that amendment up on the floor.
Yes, that'd be fine. Thank you.
Any other questions or a motion? Motion is title sufficient do pass. Strike all. All in favor? Aye. Opposed? The last that we will consider today is House Bill 1286. I call it up. It sets out how service of process shall be had in youth court cases. It simply conforms the statute to the procedural rules. Questions regarding this? Angela? I'm sorry, I'm being too casual today.
No.
Senator Turner Ford?
Thank you, Madam Chair. I was looking at line 11, 10 and 11. The parent or guardian, if the child, should they be of such parent or guardian does not have custody. I'm trying to figure out who all are we serving here. I can't hear.
So, counsel advises there's supposed to be a comma after child on line 11. Would help with the understanding of it. The parent. Are we creating a situation where the parent is not going to be served? the person or persons who have custody or control of the child, the parent or guardian of the child, if such parent or guardian does not have custody of the child.
So the language has not changed?
No.
Parent always going to be served? Would a parent always be served?
Yes, the parent will always be.
That's what my question. I don't want to hold up the bill, but that's, I just want to make sure that the
The
parent is
parent-
always going to be.
Yes, from my understanding it is, there's no substantive change here in the line.
Thank you.
Any other questions? Motion is title sufficient, do pass. All in favor? Aye. Opposed? And, that is all we have for today. Do I hear a motion?